This is part 46, and in this part we intend to start dealing with the group of the sections as far as gender exceptions are concerned, where there is incapacity on the part of a person to commit an offense. Because of what? Because of his age, because of his state of the mind, or because of the fact that he is intoxicated. So we shall be dealing with what? We shall be dealing with act of a child as a defense. Then we shall be dealing with what do you mean by insanity as a defense. And then last but not the least, as far as this group of section is concerned, intoxication as a defense is concerned. And as usual, to understand the section, first of all we shall start dealing with act of a child as a defense. And in order to understand this, we shall be dealing with two sections. One, section 82, which deals and says nothing is an offense which is done by a child who is under 7 years of age. And then section 83, which deals with, which says nothing is an offense which is done by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge the nature and the consequences of his conduct on that occasion. So these are two sections which deal with act of a child as a defense. Now to understand now, if it happens that the child whose age is 9 throws a stone into direction of Mr. D, which results into bodily pain, what is liability of this child? And now if you read section 82, which says nothing is an offense which is done by a child who is under 7 years of age, absolute liability. The child below 7 years of age. Now this is, mind well, Indian Penal Code was enacted in the year 1860. And today also this age varies as per the laws of the countries. But then we are dealing with Indian Penal Code, and what is the age? It has been taken for granted by the legislature. There is a line of demarcation that as long as child has not crossed the age of 7 years, as long as the child is under 7 years of age, it is not possible for the child to distinguish between right and wrong. If you cannot distinguish between right and wrong, no criminal intention can be attributed to an act which is done by you. And the act which is done in the absence of criminal intention is not made punishable by the provisions of the Indian Penal Code. Hence, the child below 7 years of age is not at all liable, whatever may be the act that is done by the child. Why it is so? It is so for the simple reason that this is decided by the legislature, that he has incapacity. And what is incapacity? There cannot be criminal intention. So if a child whose age is 4 throws a stone into direction of somebody which results into bodily pain, it cannot be said that child is liable, because the child is protected as far as section 82 is concerned, which says nothing is an offense which is done by a child under 7 years of age. So that is the age. Maybe the age where the child starts mixing, as soon as he crosses the age, he starts mixing with the world at large, and then it becomes possible for you to know what is his property, what is the property of other person. When then he learns, he goes on learning many things when he starts mixing with the world at large. But as the law that stands today is that nothing is an offense which is done by a child who is under 7 years of age. There is a presumption. Law has taken it for granted, and hence whatever act is done by a child who is under 7 years of age, as far as the Indian Penal Code is concerned, as I have told you in the past, this is not the time for us to have comparative study of criminal law of various countries. But during course of time, when you shall be learning the same, you will come to know this age varies as per the country. But as far as the act of a child is concerned, when the problem is before the court of law, that act was done by a child who was under 7 years of age, court will say his case falls under section 82 of the Indian Penal Code, and the question of liability doesn't arise. As compared to this, when we read section 83, which also, I mean, in continuation, there are two sections. In order to understand act of a child as a defense, we have to take into consideration two sections, section 82 and section 83. Now, what is section 83? It deals with the cases when he is above 7 years of age and under 12. So this is the group with which this section deals with, when the child is above 7 years of age and under 12. So the illustration, the child whose age is 9. Now, so he falls under this section, namely section 80. In order to determine liability, we will have to consider ingredients of section 83. Now what it says, it's not that as soon as the child has crossed the age of 7 years, it may be possible for the child to distinguish between right and wrong. It may be possible for the child to know the natural and probable consequences of his conduct on that particular occasion. And his liability entirely revolves around his state of the mind at the time of doing that particular act, and what will be taken into consideration by the court of law. When the question before the court of law is that the child is above 7 years of age but under 12 years of age, the court will definitely take into consideration what was the state of the mind prior to the doing of the act. What was his state of the mind at the time of doing the particular act? Court will definitely take into consideration behavior prior to the act, behavior at the time of doing an act, and subsequent behavior, because of which, if the court has to find out whether the child had attained sufficient maturity of understanding. Now, if the court comes to the conclusion that child had attained sufficient maturity of understanding to judge of the nature and the consequences of his conduct on that occasion, then naturally the child is liable. But if the court comes to the conclusion that child had not attained sufficient maturity of understanding to judge of the nature and the consequences of his conduct on that occasion, in that case, such a child only is protected as far as section 83 of the Indian Penal Code is concerned. So it is sufficient whether the child had attained sufficient maturity of understanding is the question that will be taken into consideration by the court of law. Now there are many situations. I mean, this is one illustration can be taken into consideration. Well, at the place of Master A, I mean, this is the group A, Master A, Master B, Master C and Master D meet during afternoon to play or for the purpose of entertainment at Master A's place. The age group is between above 7 and under 12 years of age. Master A, Master B, Master C and Master D. And what happens? The mother had some urgent words, so she told everybody that, well, you enjoy, you eat whatever you want to, you play whatever you want to, but don't fight with each other, don't quarrel with each other till I come back. And she left the place. Now they started, I mean, this is the act which is done by every child, and if you remember your childhood, they start, I mean, which is the game that should be played. They said, shall we play game of police and thief? But then in that case, nobody wanted to become a thief, everybody wanted to become a police. I mean, that is but natural, psychological aspect. And hence, I mean, they said, no, this game, hide and seek, no, we play every day. Now that was the day when they had, I mean, general impact as far when they used to, I mean, witness TV or witness, I mean, Hindi picture, maybe, I mean, any picture over there. And in there is always what is known as a scene of operation theatre. So they were four I mean, agreed that let us play a game where somebody will become a doctor and somebody will become a patient. And then here, as they were playing at the place of Mr. A, I mean, said, well, I mean, we are playing at my place, I will become patient, you become doctor. And they started playing this particular game. As for the purpose of understanding Indian Penal Code, as I have told you in the past, we always take into consideration extreme cases, and here, I mean, the facts are undisputed. I mean, everything is proved in a court of law. How it is proved in a court of law is again a question dealt by the provisions of the Indian Evidence Act with which we are not concerned. It is proved. So now they said, let us play the game. And Mr. A was lying on the table by saying, well, he was lying on a cot by saying that this is my operation, this is operation table. And then B, who was a doctor, he said, then in that case I must perform operation. For this I must have something. Mr. A got up from the bed and he immediately went to the father's room and got a blade and handed over blade and said, well, that this is the blade with which you can perform the operation. And the Master B started playing with the blade on the part of his stomach. Because of there was a bleeding which ultimately resulted into death of Mr. A, and then they were not knowing. After some time, B started telling, well, your job is over, now you become doctor, I will become patient accordingly. Both the other two, Master C and Master D, helped as a boy or a sister over there accordingly for the purpose of nursing over there. But then what is liability of one who has used the blade is the question for our consideration. They started looking at him. By that time mother came, the matter went to the police, and this was, all of them were charged. And now what is the liability is the question. Now this liability entirely depends upon what was their behavior prior to, what was their behavior at the time, and the subsequent behavior. By taking into consideration behavior, the court came to the conclusion that they had not attained sufficient maturity of understanding to judge of the nature and the consequences of their conduct on that occasion, and hence they were protected as far as section 83 of the Indian Penal Code is concerned. At the time of playing a game of hide and seek, if one boy tells you hide in this particular cupboard, and then I will lock the cupboard and the key is thrown away so that it may not be possible for anybody to find out, and he won't be in a position to find you out. Now this is a case where we say the court can come to the conclusion that regarding maturity of understanding, and hence if that is, this is applicable as far as when the person, when the child is above 7 years of age and is under 12 years of age, it is, there are some who are in a position to distinguish between right and wrong. They have attained maturity, sufficient maturity of understanding. So those who have attained sufficient maturity of understanding, they are not at all protected as far as section, they are liable, they are not protected as far as section 83 is concerned, but those who have not attained sufficient maturity of understanding, they are protected as far as section 83 is concerned. So this is when you refer to act of a child as a defense. Section 82 says nothing is an offence which is done by child under 7 years of age. And when we refer to section 83, which says nothing is an offence which is done by a child above 7 years of age and under 12, who has not attained sufficient maturity of understanding to judge of the nature and the consequences of his conduct on that occasion. In other words, now though there is no group, this is one more group, and when the child is above 7 years of age, it is a presumption that once a child has crossed the age of 12 years, the child is in a position to distinguish between right and wrong, and the child may be liable. But let me tell you, when this matter will never go to ordinary criminal court unless, when the child is about 12 years of age, and has not become major. So who is a child? And in order to know who is a child, you have to refer to the provisions of the Juvenile Justice, Care and Protection of Children Act of 2000. And the child has been defined irrespective of the sex, whether male or female. When the child is above 18 years of age, when the child is below 18 years of age, he can be labeled as what is known as a child, and he is never taken before ordinary criminal court, but he is dealt as per the provisions of the Juvenile Justice, Care and Protection of Children Act of 2000. And then if once he is above 18 years of age, he is dealt by the general law of the country as far as his criminal liability is concerned. So this is regarding act of a child as a defense is concerned, for which you have to refer to section 82 and section 83. On the same now act of a child as a defense, insanity as a defense, and intoxication as a defense, they stand on the parallel footing. The state of the mind is such that it is not possible for a person to distinguish between right and wrong, and hence the question of criminal liability doesn't arise. Then now what do you mean by insanity as a defense, for which we are going to refer to section 84, and what do you mean by intoxication as a defense, we shall be dealing as far as section 85 to be read with section 86 is concerned, as far as next part of our lecture is concerned.